Workmen Compensation Act 1923. In what conditions compensation should be given to a workman? So what it says? It says it is employer's liability to pay a workman for any injury by accident during employment or for disease in occupation. Okay, in these two conditions the employer is liable to pay the workman the compensation. Okay, there are five prerequisites. Okay, five preconditions which should be satisfied. These are: personal injury should be sustained by the employee. What is included in personal injury? The physical injury or psychological or intellectual injury. Intellect, the injury to his intellect, or the injury to his reputation. Okay, not personal property. Injury to personal property, like any goods or service, on like any goods of the workman. Injury to his goods or his property will not be included in personal injury. Examples are vehicle accidents at employment, they are come under personal injury. Or label or cylinder, they are injury to his reputation. Okay, these are all personal injuries. In Indian News Chronicle versus Mrs. Lazarus case, the workman went from heating chamber to a cooling chamber, which caused pneumonia. Okay, so this was a physical injury which was included in personal injury. Such personal injury should be as a result of accident. Okay, accident means unexpected event that results in harm to some person. Okay, so the personal injury should be a result of accident. Okay, it should be a result of an unexpected event which resulted in the harm of the workman while executing his indispensable duty, while he was doing his duty, or while in the course of his duty. Such accident arisen out of or in the course of employment. Okay, the accident should be due to the employment or during the employment. Arising out of employment means accident resulting out of work. If not been doing that work, there would not have been any accident. Ram Prasad, in Ram Prasad and others versus Rajasthan case, natural lighting was there when he was in employment. If not, he had not been there, there would not be any accident. The person was in employment at that time, a lighting strike him, so he was compensated, because it was said that if he was not in employment he would not be there and there would not be any accident. Okay, in course of employment means during working hours at the place of the employer. Okay, and he was working for benefit of employer, it will be in course of employment. The injury should result in permanent or partial disablement. Either he is permanently disabled or partially disabled. Okay, for a period more than 3 days. Okay, he should be disabled for more than 3 days, not 3 or less than 3 days, more than 3 days. The injury should result in reducing earning capacity. The injury should result in reducing earning capacity. If the earning capacity does not reduce, he will not be compensated. If accident resulted in death, the heirs will get the compensation. The heirs of the workman will get the compensation if the accident was out of or in course of employment. What are the exceptions when the compensation will not be made? It is when the disablement is not for more than 3 days. Okay, then there will be no compensation. Or it did not result in death, there will be no compensation. Or the workman was drunk or intoxicated at that time, then there will be no compensation. Or the employee or workman intentionally disobeyed the safety rules. Okay, or the employee or workman intentionally disregarded or removed the safety grounds for their safety, then there will be no compensation given to him. What are occupational diseases? The diseases peculiar to an the disease is peculiar to the employment or arisen out of employment. Okay, there are certain diseases which are peculiar to the employment, like in mines the workers get disease of their lungs. Okay, like this, these comes under occupational diseases. They are deemed to be injury by accident. Okay, they are treated as injury by accident. Okay, in schedule 3 there are three parts: A, B, C. In A, it is said if the workman is in the employment and he gets any infectious disease or parasitic disease or disease from lead, he will come under category A. If the workman is in the employment for not less than 6 months and he gets a disease of due to arsenic, mercury, phosphorus, extreme cold climate, extreme hot climate, etc., then he will come under category B. Or the worker is in the employment under more than one employer for a period specified by the central government and he gets bronchopulmonary disease by cotton or hard metals, he will come under section C. So these are the categories of occupational diseases. Now see amount of compensation. First, in case of death, the compensation will be 50% of monthly salary multiplied by appropriate factor. These appropriate factors are given in schedule Y of the act, or rupees 80,000, whichever is more, that amount of compensation will be given. If there is permanent total disablement, then the amount of compensation will be 60% of monthly salary into the appropriate factor, or 90,000, whichever is more. If there is permanent partial disablement, previous one was total disablement, total body was disabled, and in this only partial disablement. In this case, the percentage of loss of earning capacity, the earning capacity which has been reduced or lost, that percentage will be compensated. If there is temporary disablement, okay, then the compensation will be half monthly payments which are equal to 25% of the compensation. So this is Workmen's Compensation Act. Okay, let's have a quick summary. Workmen Compensation Act 1923, it's employer's liability to pay compensation to the workman or employee if there is injury by accident during employment or he gets any disease in the occupation. There are 5 prerequisites or 5 preconditions, like there should be personal injury sustained by the employee, and such personal injury should be as a result of accident. Such accident should arise out of or in course of employment. Injury resulted in permanent or partial disablement for a period more than 3 days, which resulted in reducing his earning capacity. If accident resulted in death, then the hires will get compensation if the accident was out of or in course of employment. There are certain exceptions where compensation will not be made. It is where the disablement is not for more than 3 days, and in the case of death, if the accident didn't result in death, then he will not be compensated. If the workman or employee was drunk, or he the the employee intentionally disobeyed safety rules, or the employee intentionally disregarded or removed the safety grounds, then also he will not be compensated. What are occupational diseases? Occupational diseases are the diseases peculiar to the employment or arise out of employment. They are deemed to be injury by accident. Okay, in schedule 3 there are 3 parts: A, B, C. In A, if the person is in employment and gets infectious disease or parasitic disease or disease due to lead, he will come under category A. If the person is in employment for not less than 6 months and gets disease due to arsenic, mercury, phosphorus, extreme cold weather, extreme hot weather, he will come under section B. And if the person is in the employment under more than one employer for a period specified by central government and he gets bronchopulmonary disease by cotton or hard metals, he will come under section C. Amount of compensation: in the case of death, it is 50% of the monthly salary into appropriate factor, or 80,000 rupees, whichever is more. In the case of permanent total disablement, the amount of compensation is 60% of monthly salary into appropriate factor, or 90,000, whichever is more. In the case of permanent partial disablement, It is percentage of loss of earning capacity. In the case of temporary disablement, it is half monthly payments equal to 25% of compensation. So this was Workmen Compensation Act. If you want the PDF for revision, you can get the link from description box or comment box. Next, we will cover Maternity Benefit Act 1961 in next video.